You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app, or listen on demand wherever you get your podcasts.
Welcome to the Bloomberg Law Show. I'm Kimberly Robinson alongside Greg Stohr. June Grasso is out this week. Ahead in this hour, we'll talk about the growing threats against the judiciary and the inadequacies in the tracking system meant to keep federal judges safe.
But first, the Supreme Court heard its last argument of the year this week in a case about workplace bias protections.
I want to give you a chance to just flesh out your position, which I understand has been subject to some questioning this morning, that in adopting the Civil Rights Act of 1964, Congress sought to root out discrimination, root and branch, and that all of it is impermissible and presumptively injurious.
That was Justice Neil Gorsuch summing up the employees' argument about the sweeping nature of federal anti-discrimination laws. Joining us now to explain is Robert Iafolla, who covers labor law at Bloomberg Law. Thanks for joining us.
Thanks for having me.
So, Bobby, tell us about the former St. Louis police sergeant at the heart of this case. What is she claiming happened to her?
Well, yeah, so Jatanya Muldrow was a veteran sergeant in the St. Louis Police Department, and she was assigned to the intelligence unit, which allowed her to work on investigations and wear plain clothes and drive an unmarked car. And then she was transferred. This is not something she wanted. She was transferred to sort of a normal beat cop position. So she had to go back to driving a squad car, wearing a uniform, dealing with the changing shifts of a beat cop, and that was not something that she wanted, and it led to this suit.
Okay, so this case is about the employment protections in something called Title VII. So tell our listeners, what are those protections generally meant to do?
Yeah, generally they're meant to prevent discrimination in the workplace. Title VII spells out some certain protected traits, sex, religion, race, so on and so forth, that workers are not to be discriminated against on the basis of those protected traits as they affect the terms, conditions, and privileges of employment. So here, the former police sergeant, she claimed that this transfer was based on her gender.
So really at the heart of this case is whether these sort of adverse job transfers, as opposed to something like an outright firing, are sufficient to trigger Title VII's employment protections, even if there's not a showing of specific harm. Is that right? And if so, how did that play out in Muldrow's case?
Well, yes. So with her case, the trial court and then the appellate court that reviewed the trial court's decision both looked at the facts of the case, and they said, while she didn't want this transfer to happen, she retained the same rank. It didn't affect her pay, her salary, and that basically it didn't materially disadvantage her, even though it was her preference to work on the intelligence unit instead of the beat. And because of that lack of a material harm, that's why the court threw up her claim. Like, she never got to the point of proving whether the transfer was based on gender, which would be violative of Title VII. It got thrown out because she couldn't show she suffered a material harm.
So before we talk about what happened at the Supreme Court, the other lower federal courts, have they all agreed with the analysis of the Eighth Circuit in saying that you need to show that sort of material harm?
So there's a split on that issue. Most of the courts, appellate courts that have weighed in on this issue, have agreed with the position that the Eighth Circuit took. So I think it's something on the order of 5 appellate courts have said, yeah, there's some sort of, they kind of formulate it different ways, whether it's a material, tangible harm or a significant disadvantage. It's just some way of saying, hey, what's the material harm? Why did this hurt you? But there are 2 circuits that have gone the other way. The D.C. Circuit and I think it's the Sixth Circuit have said, no, that's not a requirement to making a claim of discrimination under Title VII when it comes to transfers.
And so during the oral arguments in the Supreme Court, what were some of the concerns from the justices regarding these different tests? And I guess let's start with the lack of a harm requirement. What's the concern there?
The concern there is chiefly around what is a limiting principle. If the justices posed all sorts of different hypothetical questions, what if an employer transfers all the women workers into offices that have, one color of paint and all the men in a different color of paint? Or what if an employer, a supervisor asks all the employees, how was your weekend, except for one employee, and they allegedly did that on the basis of race or sex or another protected trait, So this is connected with this sort of policy concern about federal courts being inundated with frivolous lawsuits that they can't just get rid of at an early stage, that they have to go through stages of litigation before it could be thrown out.
And was there an answer to those concerns? What did the lawyer for the police sergeant say when, for example, presented with the hypothetical about workers of different genders being assigned to offices with different colors?
Yes, so his position was that discrimination is the harm itself. And he kind of resisted the premise of the question that they were supposed to be absurd. For example, he talked about if you distribute pink pens to some employees and blue pens to others at a random basis, that's clearly not a problem. But if you do it on the basis of race, that is a problem. But during arguments, they did talk about other sort of natural limiting principles that might emerge. The fact that an employee could prove that there was discrimination. In order to win damages, they'd have to show that they suffered an injury that needed to be compensated. So if it's the pen hypothetical, sure, you might get a jury to say that was discrimination, but you're not going to win any money. If you're not going to win any money, you're not going to get a lawyer. These sort of it comes out that way.
So what about going the other way? Let's say that the Supreme Court says that there's some kind of heightened harm requirement. What concerns do critics of that side have?
Yeah, an argument is that it basically would allow for segregation in the workplace based on gender or race or other protected traits, which they argue that Title VII clearly does not allow.
Did you get a sense in the courtroom of which way the justices were leaning on this question?
Yeah, it did seem like there was a small minority of justices that were extremely concerned about this question, about trivial differences creating frivolous lawsuits and the negative consequences of that. But that was only maybe two or three justices seemed to focus on that. The other justices seemed to really embrace the workers' argument that the harm of discrimination is the discrimination itself.
And so, there's been a lot of talk over the years that the Roberts Court is friendly to businesses, that it's a business-friendly court. So this sort of suggests the opposite in this case.
Yeah, well, each case is going to be a separate issue. And with this issue in particular, for example, when Brett Kavanaugh was a D.C. Circuit judge before he ascended to the bench, he was in a case that dealt with this issue. And at that time, there was binding precedent that had to be applied that required a material harm. But he said in a concurring opinion, the D.C. Circuit should change their case law and get rid of this requirement, and which is something the D.C. Circuit did a few years later. Or also take Neil Gorsuch, for example. In some respects, a rock-ribbed conservative justice, appointed by former President Trump. But at the same time, he wrote the case that expanded Title VII's protection to cover gender identity and sexual orientation, which it was something that businesses did not want at the time, but he grounded that decision in the text of Title VII. Today he asked a lot of questions that indicated that he was firmly grounded in the text of Title VII when he talked about there not needing to be an additional requirement.
Well, coming up on the program, we'll get more on the Title VII case in front of the justices with Robert Iafolla. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast on Apple, Spotify, or anywhere where you get your podcasts. I'm Kimberly Robinson.
And I'm Greg Stohr. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch the program weekdays at 10 p.m. Eastern on Bloomberg Radio, the TuneIn app, Bloomberg.com, and the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
I'm Kimberly Robinson.
And I'm Greg Stohr. We're in for June Grasso.
But are you saying then if the employer wants to increase diversity in the workplace and so promotes, say, some black employees and they get better jobs, then that's discrimination?
That was Justice Amy Coney Barrett wondering how a broad view of employment discrimination protections might play out in future cases. We've been speaking with Robert Iafolla about employee bias protections being considered by the U.S. Supreme Court. Bobby, we're going to get to Justice Barrett's question in a second. But first, let me ask you, this case had kind of a quirk to it in that the question that the St. Louis police sergeant asked the Supreme Court to consider is not the exact question they're actually considering. Can you explain what happened and how that might be affecting what the court does?
Yes, that's right, Greg. So originally when Muldrow petitioned the court to review the Eighth Circuit decision and revive her gender bias lawsuit, she asked a much broader legal question about the need for a showing of material harm for any workplace decision that affects terms, conditions, and privileges of employment. So you could imagine that could cover things like work assignments, where you're assigned to work. Do you have to work outside in the heat? Can you work inside in the air conditioning? What job functions you have to perform, all sorts of different things. But the court, when they accepted her request to take this case, they narrowed it down and to just job transfers, just the material harm requirement for job transfers, not for a whole myriad of employment decisions that could potentially be illegally motivated by race or another sort of biased decision.
Okay, but we've already on this program talked about things that go well beyond transfer, right? We talked about the color of pens. We talked about the color of offices. So this is something that confused me about the argument was there was discussion on this broader point, right? And whether there's some sort of de minimis discrimination that sort of is permissible by Title VII. Is that right?
Yeah, so on the one hand, I think that some of the justices were using those examples kind of to deploy the weapon of absurdity to point out, why you need a limitation. So some of these situations are not real, like the assignment of colors of pens and whatnot. But also they had some concerns about these situations. But at one point, Justice Jackson brought it back to the narrow question presented, and she said quite directly, hey, look, I thought we narrowed this question to just transfers so that we didn't have to worry about this sort of issue about what is trivial and all sorts of random and potentially discriminatory workplace actions.
So the case before the Supreme Court is being pressed by a woman claiming discrimination, but there's also the specter that whatever rule the court comes out with could be used by people pressing so-called reverse discrimination cases, namely, let's say, a white person saying an employer's diversity policy discriminates against them. We heard that question from Justice Barrett asking about that subject. Was there any more from the court on that? Do we have any kind of indication as to whether corporate diversity policies might be affected by this case?
Well, Justice Thomas also asked whether the workers' definition of discrimination here and the need for no material harm could run headlong into efforts to diversify the workplace. So it's clearly on the court's mind. It seems like with this narrowed question presented, the ruling will most likely deal just with transfers. But you could imagine that there'll be all sorts of commentary in the opinion that down the road litigants might point to, whether they be folks worried about discriminatory employment actions that aren't transfers, or whether they're raised by the sort of people that you're mentioning, folks who are against quote-unquote reverse racism.
And then, surprisingly, bathrooms have been a topic at the U.S. Supreme Court over recent terms, and sort of wondering, that came up in the argument too, is that going to be one of the areas where, this case could potentially have a broader impact, the idea of access to bathrooms for, transgender students or transgender workers?
Yeah, I was sort of surprised when that came up in the arguments myself, when the parties were discussing, possible exceptions to this idea that discrimination is, by definition, a harm that people suffer, that attack to your dignity and stigma attached and these sort of things. But when discussing this, I believe it was the lawyer for the Solicitor General's office, the Biden administration lawyer, had brought up bathrooms as one of the examples of an area that traditionally we've just viewed. It's essentially sex discrimination, right? To say that women go to the bathroom in that room and men go to the bathroom in that room, but that's an example of an accepted discrimination on the basis of sex that nobody really questions. But of course, it is coming up in cases about bathroom access for transgendered individuals. Again, I think it's similar to the issue with the diversity programs, that I do not believe that there'll be any holding directly on point about the bathroom issue, but there may be stray discussion in the majority opinion or in a dissenting opinion that litigants down the road might seize on, litigants on either side of the debate.
Bobby, stepping back just a little bit, so this court in many ways is a very conservative court. I think a lot of people listening might be a little bit surprised that this court, even though this may end up being a narrow decision, might be ruling in favor of employment discrimination suits. And it wouldn't be the first time they've done that. You mentioned the case involving suits by transgender people and suits alleging sexual orientation discrimination. What's going on here? Can you sort of encapsulate why the court is doing something that to many people might be counterintuitive?
Yeah, from my perspective, I think it comes down to judicial philosophy. Essentially, judges that tend to hail from the right side of the political spectrum also claim allegiance to a way of interpreting law known as textualism, where they're not interested in the legislative history that might have gone on that led up to the writing of a law. They're only interested in what the words on the paper say and what those words meant at the time that they were written. So in this case, the workers' attorney really leaned into this. It's really about, what does Title VII say? Title VII does not explicitly create any separate harm requirement. It just says it's unlawful for an employer to discriminate against any individual concerning terms, conditions, or privileges of employment because of their sex or race or other protected traits. So in that respect, it kind of fits right in with some of the justices on the court that are conservative justices, but they're textualists.
Well, our thanks to Bloomberg Law's Robert Iafolla. Coming up next on the Bloomberg Law Show, we'll take a look at threats against federal judges and what the government is doing to try to stop them. I'm Kimberly Robinson.
And I'm Greg Stohr. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app, or listen on demand wherever you get your podcasts.
I'm Greg Stohr.
And I'm Kimberly Robinson, in for June Grasso. Up now, the number of credible threats against federal judges climbed in recent years, with more than 180 substantiated threats against federal judges from January to March of 2023.
2 weeks ago, my life as I knew it changed in an instant, and my family will never be the same. A madman, who I believe was targeting me because of my position as a federal judge, came to my house.
That was federal judge Esther Salas in 2020 after a gunman opened fire at her home, killing her 20-year-old son and severely injuring her husband.
Here to talk to us about threats against judges and the government's efforts to thwart them is a familiar voice. Bloomberg Law's Lydia Wheeler, who, when she's not filling in as a host on this show, covers the Supreme Court and the federal judiciary. So, Lydia, you recently wrote a story about judicial security and threats against judges. What did you uncover?
That's right. So I actually learned in my reporting that the United States Marshal Service can't fully assess the security risks that federal judges face because its system for tracking threats doesn't allow marshals to cross-reference behavioral information and spot suspicious activity that could actually help them connect cases. So former marshals told me that the system that they're using now was actually built to keep tabs on prisoners and fugitive investigations, not actually track threats and inappropriate communications against the judiciary. One former marshal, put it to me this way. He said, think about if there's a little red Corvette seen circling the federal courthouse in Omaha, Nebraska on Wednesday, and then a red Corvette is spotted circling a federal courthouse in Little Rock, Arkansas on Friday. Intelligence analysts really need to be able to connect those dots pretty quickly, and that's something that they can't do right now.
Well, is the Marshal Service working on a fix for this problem?
Yeah, they are. So the Marshal Service has been working on this for some time. They've been working to transition the entire agency over to a new system called Capture. That former marshals I talked to told me that it would let the Judicial Security Division actually break data down into more detail, track threats by district, by judge, by, person who made the threat and how the threat was communicated. But funding issues and competing priorities have really contributed to the project's delay.
So what sorts of threats are judges getting?
For this story, I actually looked at cases of people who have been federally prosecuted for threatening a judge just to get an idea of the type of threats that, judges are getting. And I can tell you they're often very explicit, and some are actually pretty scary. So, the threats are most often communicated by email. They come to the judge's chambers by phone and are left in a voicemail message. And oftentimes they come in handwritten letters. So I actually came across one case from 2017 that was against a man in Connecticut who threatened to harm a federal bankruptcy judge in a handwritten letter that he put in her mailbox at her home. So he actually knew where she lived. And, it was basically telling her, don't go too far in this hearing, back off, I'm warning you. And, oftentimes the threat goes beyond not only the judge, but also targets the people who are closest to them. So it will say that they, the threatener often threatens a spouse or the judge's children as well.
So in looking at the people who have been prosecuted for threatening a federal judge, are there any similarities among those people?
There definitely are. So we teamed up with Peter Simi, who is a sociologist at Chapman University. He's actually been studying threats against public officials at the National Counterterrorism Innovation, Technology, and Education Center at the University of Nebraska, Omaha. And so with his data, we were able to look at cases from the last 10 years. And, looking at this, wealth of information, we found that most often, threateners have some sort of a connection to the judge that they're threatening, or at least a connection to the case that judge is hearing. So meaning they've either had a case before the judge in the past, or they know someone who has. Sometimes, though, the person is just really upset about the case that the judge is presiding over. So think back, we've reported in recent months that Judge Tanya Chutkin has gotten death threats. She's the judge that's overseeing that criminal case right now in D.C. That's accusing President Donald Trump of conspiring to overturn the 2020 election results. We also found that people who threaten judges often have a criminal history already. Lots of them have mental health issues, and several of them are motivated by ideology. So, Peter Simi at Chapman University, found that in his research that actually right-wing extremism ideologies tend to be the most prominently presented here. And so, but threats are also coming in, from people on the other side of the political line, too. if you'll think back, Judge Matthew Kaczmarek, who's a federal district judge in Texas, he got a barrage of death threats and harassing phone calls in March when he was hearing a big case over a key abortion drug known as mifepristone. And I'm sure you both remember the man who was found, outside of Justice Brett Kavanaugh's home. He was armed with a pistol, and he told investigators that he was there to kill the justice because he was upset about the court's leak of the draft abortion decision.
Lydia, in your story, you distinguish among different types of people who make threats. You said that there are hunters and there are howlers. Can you describe what those are?
That's right. So the marshals refer to people who threaten judges repeatedly as howlers. Those, and then those are people who repeatedly send messaging or threatening messages, but they don't ever act on them. And then there are people who actually go out and seek out the judge and attack them, and those are known as hunters. And I'm told that they're rarely one and the same. So meaning howlers don't often turn into hunters. But marshals, former marshals told me that it's impossible to know kind of which threats are credible and if a hunter or if a howler is going to become a hunter eventually, unless they actually investigate and look into the threat itself. I will say that the judges and the former marshals that I spoke with all praised the work of the Marshals Service and spoke about how judicial security is just a really difficult job, even with the best analytical tools. Several of the judges I spoke with just, wanted to make that clear, that they have a really hard job, even if they have the best tools.
So you said you spoke with some federal judges. How do they feel about these threats and sort of what's going on with the marshal's office?
Yeah, that's right. So I spoke with Judge Timothy Corrigan. He now serves as chief judge of the U.S. District Court for the Middle District of Florida. He said that threats are just part of the job and that he has to deal with them, but that it's actually really hard on his family. And that's the hardest part to think about, that because of what he chose to do for a living, he's now putting, those that he loves the most at risk. And Judge Corrigan is interesting because actually in 2013, he was nearly assassinated at his home when a gunman took aim outside his window. He was just relaxing in his recliner watching TV, and, all of a sudden there was this big explosion. In the investigation afterwards, they found out that the bullet had missed his head by 1.6 inches. In that attack, the attacker was actually able to sneak away from the scene, and he ended up on the list of possible suspects because he had a warrant out for his arrest. He had violated, I guess, the terms of his supervised release and was actually due back before Judge Corrigan. But Judge Corrigan told me that he didn't even remember him very well, and the only reason he made that list of potential suspects was because he had that warrant out for his arrest. But Judge Corrigan has gotten threats since then from other people. And, like I said, he said they're just a feature of the job. And he said that they don't try to affect him that much on the bench, or, that they aren't really having an impact. But, the sociologist I spoke with said, judges are human, and these threats could impact, how they form their decisions and how they rule on the bench.
Lydia, you said they are increasing now. Is there a broader effect on the federal judiciary?
Yeah, so my sources are telling me that, a threat against a member of the judiciary is really a threat against democracy, and that it's not tenable for democracy to have people expressing their grievances and lacing that discontent with threats of violence, at this volume. So, the sociologist I spoke with said it suggests that a certain lawlessness is acceptable and actually becoming normalized. So, yeah, this is, the broader impacts are pretty great here.
So, Lydia, we heard previously from Judge Esther Salas, who was involved in an attack in 2020 by a gunman that killed her son and injured her husband. Can you tell us what happened with that case? There was some legislation that came as a result of that, right?
Yeah, that's right. Judge Salas actually lobbied Congress after that horrible tragedy to pass the Daniel Anderl Judicial Security and Privacy Act in 2022. And that law aims to make judges' personal identifiable information harder to find online. And so actually I reached out to the Administrative Office of the U.S. Courts And they told me that since that law passed, about 3 million individual pieces of judges' information have been removed from the internet since then. So we know that the law is having an impact. And Judge Salas told me that she also got a similar legislation passed at the state level in New Jersey, and she's working for other states to pass a similar legislation as well. She's really made it her life's mission now, without her only son still living, to have some sort of impact on judicial security and make judges safe so no one else has to go through this horrible tragedy.
Lydia, is there reason to think that the removal of all that information has indeed made judges and their families safer?
It has in some respects, but judges and former marshals that I spoke to said that there's no way to remove all of the information from the internet. It's hard to keep track of all of it, and it's hard to find it all. And there's always going to be information on the dark web, and so that's going to continuously be a risk. But this is a step in the right direction. I actually chatted with a former marshal who trains judges on security, and he said that they needed to be proactive and be a participant in their own survival. So he basically advises them to get a home security system, be really mindful of their social media posts. He said that they should protect their private information the best way that they can. It starts with them, and that when they are out of the office and, outside of the federal courthouse, that they should pay attention to their surroundings. And if they see something suspicious, to report it. Judge Salas told me that she, prior to this attack, she had actually seen the attacker on her street and had seen him ahead of time. And former marshals say that they hear this kind of thing, all the time from some judges that, they'll get that kind of intuition of like, oh, that doesn't feel right. And they don't report it. Or they don't know that they should report it. And so this former marshal was saying, definitely if something rubs you the wrong way, it's better to err on the side of caution. So really to trust your intuition and to take all the threats that you're getting seriously.
So Lydia, wondering, is there any other advice that's given to judges on how they can protect themselves and keep themselves safe while on the bench?
Yeah, so, marshals are basically just saying that, pay attention to the threats that are coming through. It's easy to disregard some that you think are just like completely, outlandish. I mean, some of the threats that I read, you can tell that the person that is writing them is suffering from some mental health crisis, but that doesn't necessarily mean that person won't act on that threat. So it's important to make sure that you're reporting them. And then to also that, marshals told me that it's important, or former marshals, I should say, told me that it's important that judges kind of follow up and say, like, hey, where are we with that? And kind of, like I said, be an active participant in their own security.
Lydia, we haven't talked about state court judges. Are they getting similar types of threats?
Definitely. They're 100% facing the same kind of threats that federal judges are facing, and some of them have had really horrible tragedies, like some federal judges have. Just recently, in October, there was a Maryland state court judge who was shot to death in the driveway of his home. The prime suspect was actually a man that had lost custody of his children in a divorce hearing earlier that day in front of the judge that he shot. And, police actually found that man about a week later, deceased. So while marshals are tracking threats against federal judges, I've been told there is no national repository for threats against state court judges, and there's way more of them. I mean, we're talking about like over 30,000 state court judges across the country. And, states either aren't collecting this data, or they're not collecting it consistently across states, or they're not reporting it publicly. So it's really hard to tell kind of what state court judges are facing. And they don't have the protection of the Marshal Service. So actually those people are less protected.
Sounds like a lot of work to do. But thank you to Lydia Wheeler. That's going to do it for this edition of the Bloomberg Law Show. I'm Kimberly Robinson.
And I'm Greg Stohr. Stay with us. Top stories and global business headlines are coming up right now.